Welcome to the Early Intervention and Special Education one-on-one presentation. This is sponsored by a grant from the Pennsylvania Developmental Disabilities Council through the Disability Advocacy Support Hub DASH. DASH is a project that helps disability advocates make positive change in their communities, and it is being delivered today by Disability Rights Pennsylvania. My name is Court Wayberg, and I'm a staff attorney at Disability Rights Pennsylvania. I'll be working with Sherry Mammis, another one of our staff attorneys, on this presentation. If you have questions about DASH, you can contact Lando at Disability Rights Pennsylvania, 103 Chestnut Street, Harrisburg, PA 17101, by phone at 800-692-7443, extension 312. By email at ldo@disabilityrightspa.org. So today I'm going to start off with talking about some advocacy tips for parents and folks who advocate for children with disabilities in the early intervention system with special education, and that's children ages 3 to 5. And then we're going to get into the meat of the presentation and talk about how special education law affects children in the early intervention system. So the bulk of the presentation will be talking about that.
Our guiding inspiration for this morning is to never doubt that a small group of thoughtful, committed citizens can change the world, because, of course, indeed, it is the only thing that ever has. So keep that in mind as we work through any frustration or anger that you're carrying over from some bad experience, because, again, to be an advocate, you gotta focus on the wins as well as work through the struggles. So we're going to talk about those things today. Since we're going to start off with a few advocacy tips, we wanted to make a distinction between collective versus individual advocacy, again, in the context of special education and advocating for children with disabilities. Today we're going to talk about collective advocacy as when members of your group or organization come together to promote and support change to improve the educational opportunities for all children with disabilities in a particular school district, or statewide, as opposed to individual advocacy, where we're promoting and supporting the educational programs and services for a single child. Again, I'm betting that probably the majority of our audience today has had experience in one or both of these categories. Oftentimes it's individual advocacy on behalf of a child, but there are a lot of groups, family-based groups, school-based groups, task forces that get together in this area, in this context, and do promote change. Sometimes just at the school level, but oftentimes at a district level. And once in a while we have the opportunity to make change at a state level or federal level, like when a reauthorization of a law is coming up, or they're going to play with regulations, and we all put our heads together and have bigger input. So it can be statewide or nationwide. So general advocacy tips, these again could be helpful to you in particular in a situation. I often find these tips are very beneficial to families and to parents. This area of law, this area that we're dealing with in education, involves children and parents, so it is a very highly charged emotional issue for a lot of families. And it is sometimes very easy to get carried away. So these tips are really, I think, dynamic. So if you do work with parents or children or relatives that are advocating for children, it's good to tell people, especially parents, if they're going to go to a meeting, especially if they're going to bring an advocate or some family members or some friends to come with them, to appoint one person to be the official note taker. If you're a parent or just someone who's making a case or point on behalf of a child, it's very hard, at least I think it's very hard, to make your, to be articulate and to be oral, and then at the same time be trying to take down notes about what the other, 5 to 10, 15 people are saying at the table. So having an official note taker is a good tip for families. Listening carefully and communicating clearly. Very basic, obvious, but when you're very involved and you're really focused in on making a point, sometimes we're not as receptive listening as we should be, where we need to remember to hear what the other person is saying or what the other people are saying, so that we can process how that impacts what our position is and what we're trying to do. And communicating clearly. And I know this from my personal experience. A lot of times when somebody comes to me with a problem, it takes a while to get to what the problem is, right? Because the person wants to tell you about the problem, but they also want to tell you about the things that led up to the problem or the other 20 things that are going on simultaneously. And sometimes it's not even clear to get to the point of what the issue is or what the person wants as a remedy or result of the issue. So trying to remember to focus in on listening and communicating clearly is a really good tip for everybody. Asking for clarification if you don't understand something, that's a good one because I myself am guilty of this. You know, especially if you're in a group of people and there's a lot of conversation going on, and sometimes somebody may say something, you're not quite clear what they mean, and you may be a little embarrassed to ask because you don't want to look like the one person at the table who didn't get it, but chances are you're not. So trying to remember to ask for clarification is important. By the same token, asking for specificity when something is too general or vague, that's a good tip because, you know, a lot of times, especially when you're talking in a group of people, people say things that sound really good when you're at the table and it sounds like it's what you want and it's the result, and then an hour later when you're thinking about what's going to happen next and you can't really figure out what it is that's going to happen next because there wasn't any detail, right? The devil's in the details. So getting to that specificity sometimes, you need to stay focused on that in a group meeting as well. And remembering, and again, this is more for, I think, families as opposed to advocates who may be more familiar with being in meetings and having group discussions than maybe a particular parent is for their child. It is okay to feel frustrated or angry, but to try to remember that focusing in on the facts is more effective in achieving an outcome than letting the anger run away or getting too frustrated in a meeting, because if you go to a meeting and it turns out that you're spending the first 15, 30 minutes, an hour fighting about what the problem is, you're wasting time where you could just sort of agree to disagree and focus in on what should happen next or what's going to happen next, or figuring out exactly the point in which nobody's going to compromise, right? So staying focused, even in frustration and anger, is a really difficult but beneficial skill. And to the extent that we can do that for ourselves and also help the people that we're advocating for do that, I think benefits the entire group. So dealing with objections, attitudes, and stress. Okay, remember, when you're dealing with stress, especially in a special education context where by definition decisions are made by a group of people, you have to remember that you are sitting in a room with a group, but every person at that table has an independent and individual personality. So realizing that there are many personalities in that meeting and how to address people as individuals is very important. Just a good advocacy tip in general. Again, a lot of times things don't get resolved more because of the personalities that are at the table than because it's an issue that's insurmountable, because most issues are resolvable. It's just sort of working through the personalities and the objections and the attitudes to get there, right? So we have to remember, try to deal with people as individuals. Please be mindful of, you know, where they're coming from and maybe why they're taking the position they are, and trying to work positively around that. When you are addressing a group, learn to engage the entire audience, you know, so that you don't appear to be favoring one member over the other. Again, that's just good advocacy strategy. You want everybody to feel involved, especially in a group decision-making process. And then list objections and obstacles for brainstorming and problem-solving later. Don't become unnecessarily defensive if it doesn't advance your goal. So again, this goes back to, don't spend the first 30 to 45 minutes of a meeting fighting about an issue where it's clear that you're not going to resolve. You know, put it on a list of to be decided, and try to figure out as much as you can resolve. You know, make the meeting as productive as possible. Do all the low-hanging fruit, right? Get all that out of the way, and then what you're left with is a shorter list of things that maybe you're going to need to take a different approach to. Just good meeting strategy in general. And finally, once we advance to the next slide, we're going to talk about outside networking and resources. Sometimes, again, it's going to depend on the issue and the situation, but sometimes an individual is not able to solve a problem by themselves. And so it is always beneficial to thinking about who else can you reach out to that may help you with whatever the issue is that you're dealing with. So are there other organizations or groups or individuals that you could reach out to, just maybe for the purpose of gaining information? You know, sometimes to successfully advocate and make a change, you need data, right? You need to have information at your hands that's going to support your argument and your position. And sometimes you can find that, depending on who else is looking at it, who else has collected information. So that's one reason. But also to cultivate partners. And again, this is more, I think, towards the collective advocacy, but if you're going to try to make a bigger change, having more people who are interested in the issue and are like-minded about it is obviously going to be beneficial. So figuring out at the beginning is a good strategy, right? Who's out there that's on your side? By the same thing, who's out there that's not on your side, or who would be somebody or a group or a person or an organization that may oppose your efforts, and take that into consideration as well, because you want to have your idea of, what is my position, what is the opposing position, and how do we get to a resolution, or how can I resolve this conflict. And using the media, this can be an effective tool. This is not something that I think people jump to necessarily in every case. Again, it really depends on the issue and the circumstances. But it can be a very effective tool as well, especially if you have a very compelling story, or if you have a group of compelling stories and you want to make change. You can use the media to sort of bring attention to the problem or the situation, and to build, sympathies and like-minded people who do see this as a problem and do agree with you. So being skilled at using the media is something that you should also take into consideration, especially for collective advocacy. Okay, now we're going to jump into the meat of the presentation, which is the Special Ed 101 part. And where I like to start, and where I think is the most logical place to start when you're talking about special education, is what the law says. Because the whole reason that kids have special education services and get programs and supports is because there's a law that says they do. So we need to understand, again, what the entitlements are and where they come from. And in special education world, the most important law that governs the rights of children and families who have a right to something in school, and the corresponding obligations of who's responsible for doing that, is governed by the federal law, which is the Individuals with Disabilities Education Improvement Act. That's the name that was actually given in 2004. We all still call it, or most of us still just call it, the IDEA or IDEA. Sometimes people will say IDEA 2004. In your PowerPoint presentation, you will see an actual link so that you can actually pull up the federal statute. So this is like the granddaddy of the law that applies to children with disabilities in the public education context. As with all federal statutes, there are federal regulations that are then implemented that try to break down the overreaching statute and break it down into manageable parts and be more specific about what the rights are, what the entitlements are, what the responsibilities are. So the federal regulations, which were promulgated to implement the IDEA, there's a citation for those. Those are at 34 CFR Part 300 for school-age children. Then, of course, we have state law. So we have our federal statute, we have our federal regulations, then, of course, Pennsylvania has a state law where we're also now going to put together some laws that, again, benefit these children, convey to school districts, public education entities what their obligations are. And in Pennsylvania, for special education purposes, we call that Chapter 14. So if you've heard of Chapter 14, you're referring to the state law that protects children with disabilities in public education programs. And also in Pennsylvania, we have charter schools. And charter schools are public schools, and therefore they do have obligations to children with disabilities. They do have to follow the IDEA. And the state law that governs the charter schools is found at 22 PA Code Chapter 711. So that's sort of the overarching framework of where these rights and responsibilities come into play. Now, that's special education, and that's what happens for kids in school with regards to programming and services. There are other laws out there that do protect individuals, including children, who have disabilities that are not specific to special education, but may be beneficial and protective of children with disabilities in public settings, including in school settings. So some of you, maybe all of you, have heard of the Rehabilitation Act of 1973 and the federal regulations which implement that, as we refer to as Section 504. Those laws exist as well. The Rehabilitation Act actually predated the IDEA and is a federal law that prohibits discrimination against people solely on the basis of disability. So those laws may come into play, and oftentimes do come into play, depending on the situation for a child with a disability, whatever the issue is. The Rehab Act, Section 504 regs may also be beneficial to that student. We have state regulations again, Chapter 15, if you're familiar, if you've heard of Chapter 15 under state law, is the state law that mirrors the rehabilitation. So again, not special education, so to speak, but a law that protects children with disabilities to make sure that they're not discriminated against in school. And finally, we have the Americans with Disabilities Act, which I'm sure most of you have heard of. Again, a law that prohibits discrimination, and Title II of the ADA does apply directly to public entities, including public school districts. So all of these sort of pieces are out there at any given moment for any given issue that may be very relevant for an issue that's facing a student with a disability.
Just to add to what Sherry just said, all the laws she just talked about also apply to children in the early intervention system, again, age 3 to 5. Again, I just want to underscore that the IDEA is certainly the most relevant law to early intervention, but certainly the other laws do apply. So before we really get into the law on special education as it applies to children in the early intervention system, I think it's important to step back and look at who the key players are in the system. So I want to start with the child and the parent. You might think that that's rather obvious, but you'll notice the parents in quotes, and that's because the IDEA has a special definition for parent. It certainly can apply to what some people would call the traditional parent, two parents living happily married, biological parents, but depending on the circumstances, it could be a single parent. It could be a grandparent raising a child by themselves. It could be an adult who's an adoptive parent or a legal guardian. It could be, if a child's in foster care, it could be a foster parent. So it's important to remember that the IDEA has a rather expansive and nuanced view of that. So moving on, we have the local education agency, and for children in early intervention, that's almost always going to be an intermediate unit, and there are intermediate units that are, make up a whole county, several counties, but intermediate units are responsible for at least providing early intervention services, placing children in preschools, providing other services such as related services, which we'll talk about later. I do want to underscore something different for Philadelphia and Chester and other parts of Delaware County. Services there are delivered by a private company called Elwyn. It's the only part of the state where an intermediate unit is not responsible for being an early intervention child's local education agency. And as far as the state education agency that's responsible here, for all early intervention children in PA, it is the Pennsylvania Department of Education. But for early intervention, there is an office within PDE that's responsible. It's the Office for Child Development and Early Learning. The acronym is OCDEL. You might hear people refer to it as such. And that is the office within PDE that is responsible for spearheading early intervention throughout the state.
So what is it? What is this cool thing, that students with disabilities get under these laws, under the special education laws? Well, what the entitlement is an entitlement to a free, appropriate public education. And for those of you who are familiar with this area of law, we affectionately call it a FAPE. So the FAPE is the entitlement. And if we break that down a little bit, we'll maybe have a better understanding of what it means. So let's start from the end. We are talking about education. So the entitlement is for services that are meant to bring educational benefit to students in school. Kids with disabilities have sometimes a lot of services from a lot of different systems. They may have a lot of different needs. Sometimes children with disabilities also have medical needs. Sometimes their medical needs or other types of needs may have to be dealt with during the day while they're in school. But the entitlement that they get from their local education agency is to an appropriate education. So anything that's provided through the local education agency is going to be educational in nature and has to be able to have an educational benefit for the child. Public means that, again, we are talking about a system that is available to children who are involved in public education in some way. So if they're in their public school district, or if they're in their public intermediate unit, or if they're in a public charter school. Now, there may be circumstances where a child is in a private school and getting a FAPE, and we will talk about those a little bit later when we talk about placements for kids. But in general, all kids who are somehow tied into the public system are going to get an entitlement to FAPE. Appropriate is probably the most difficult conceptual term because there is no one definition for appropriate. It is totally dependent on each individual student. So what is an appropriate education for Johnny may not be an appropriate education for Mary. The group of people, the parents, the education agency that are coming up with these programs and services, again, it's all about the individual child and what's appropriate for that child. And free is somewhat of a misnomer because nothing is free. Everything costs money. But the free entitlement to services, it's free to the family. It's free to the child. And again, it's not really free because a lot of people pay taxes and your tax dollars go towards this, but families are not going to be charged per kid for special education services. So the school district is going to be responsible, the intermediate unit is going to be responsible, the charter school is going to be responsible, the child's going to benefit, and again, the family's not going to have any direct costs in a typical situation. So when we talk about this entitlement, we're going to break it down and we're going to spend the rest of the morning going through the steps on how you get there. But again, the overall sort of bird's eye view of this is to get a FAPE, there's a couple of key components to getting there. The first of which is you're going to have an evaluation for a student to see if they're eligible to get this FAPE, this entitlement. And there's a lot of acronyms in special education law, as I'm sure most of you know. To get an evaluation, you're going to get a report at the end of that evaluation, which is called an evaluation report or an ER. There's also an option for families under the federal law to get an independent educational evaluation, which is abbreviated IEE. The evaluation is sort of the first step in the process, which we're going to talk about in a minute. Once you have an evaluation, then you're going to get a program. And again, because it's got to be an appropriate program for an individual child, it's going to be an individual program, an individualized education program, or an IEP. And then another component, once you have your program written nicely in your IEP, which is your services, is you're going to get that program implemented in a placement. And the law requires that placement be the least restrictive environment, which again depends on the child and what the program and services is going to look like. And where can that all be implemented that is the least restrictive to the child? And we will again talk more about that, but that is abbreviated as LRE. So that's the substantive part of special education law. We also have some procedural parts of the law which allow families and school districts who may not agree on any of those things, or any one or more of those things, to have a system to resolve disputes. So that's on the other side, which is the procedural side. We have procedural safeguards. So anytime a school district, a charter school, or an intermediate unit, a public education agency is going to do something or not do something for a child, they're going to give the family side notice of what their decision is. That's going to be embodied in what's called a Notice of Recommended Educational Placement, or a NOREP, or a NOREP, depending on how you like to say it. And then that's the written notice that families get. And then there's also a system, again, once it's in writing, here's what we're going to do, here's what we're not going to do, here's what we've considered. Then there's other ways any disputes can be resolved. And we are going to spend some time this morning talking about what those look like as well. But we're just going to say those are going to be the dispute resolution mechanisms. So there will be options on how to deal with any issues. And again, if you go from the premise that everybody in the group has an idea, has an opinion, has a reason for their belief, reasonable people can disagree, right? Reasonable people can disagree on services. Reasonable people can disagree on programming and placement. So it's okay. It's not like somebody's always right and somebody's always wrong. There can be disagreements. There's a lot of stuff happening. So there's a lot of points in the spectrum on which there can be disagreement. But rest assured, we have procedural safeguards to allow those things to be resolved.
I just want to add, before we move on, that 60 calendar days evaluation requirement for children in early intervention, that actually does include days during the summer months. So when parents request an evaluation and they're keeping track of how long it takes, with 60 days, they should definitely include summer months if their child is 3 to 5.
Step one is the evaluation. And so now we're going to dig a little deeper into the process of getting to this FAPE entitlement for children with disabilities. And the first step, as we said, is an evaluation. Now, in a lot of cases, maybe the majority of cases, the family is going to request an evaluation for their child to see if their child is eligible for this FAPE. I want one of those things, those IEPs. I want an evaluation. So there's got to be a request for an evaluation. This has to be in writing. It can be oral, if a parent talks to somebody, a teacher, or a principal. Ultimately, what should happen is that person should then reduce it to writing and have the parent sign a permission to evaluate form. It's not a bad thing to have the request in writing. So again, there's a clear communication of what the parent wants. They would like a special education evaluation, and there's a clear timeline for when they made that request, because we do care about the timelines. There are requirements for how long these things can take, which are governed by the law. So putting it in writing, either the parent can do that at the front end, or hopefully if they communicate orally to a school district person, that person will help them get to the right place. But the first step is to get the request form, and they're giving their permission to evaluate. What the district or the local education agency will do at that time is get that request and make a decision. This is decision point 1 for the district, which is, are we going to do the evaluation that's being requested, or are we not going to do it? And they do have a choice. Now, in a lot of cases, they will agree to do it, and what will be issued then is a consent to evaluate form, which gives them permission from the parent, the decision maker, that they can go forward and do their assessment. If they choose not to, they still have to give the family notice that they're not going to do it. That's what that NORA would look like. And then the family can decide whether they want to accept that or if they want to go a procedural route and pick a way to resolve that through the procedural system. But in a lot of cases, the district will go ahead and do an evaluation. Again, there's a timeline. You will see that from the date of that, once the consent is given and the district has agreed, they have those 60 calendar days to do the evaluation and to issue the evaluation report. Now, the days that don't count are summer break days when the school is not in session. So although a parent can request and give permission at any time, if they wait until the end of the school year before they ask and they give permission, they may not get that evaluation until the following school year because the summer break days don't count. But typically, we're going to be counting the 60 days on calendar.
I just want to add, before we move on, that the 60 calendar days evaluation requirement for children in early intervention actually does include days during the summer months. So when parents request an evaluation and they're keeping track of how long it takes, with the 60 days, they should definitely include summer months if their child is 3 to 5.
Now, for families who may not understand special education, and again, who does, right? This is probably not a topic that most people are comfortable talking about around the coffee table. For families who may not understand special education or don't know the system or don't know that they need to request an evaluation, school districts or public education agencies also have what's called a child find duty. So even for cases where a parent is not understanding or doesn't know that they should be looking for an evaluation, if a school district or an LEA sees a child struggling and they suspect that this issue or issues may be related to an underlying disability, they have a corresponding obligation under the law to notify the family that, hey, we think, your child is struggling. We have some reason to think that it may be related to an underlying disability or disabilities, and we'd like to evaluate. And at which point the family can give their consent to evaluate or not. But I don't know, I don't have the data, I don't have the statistics about how often districts approach families, but that is really what the law requires. So again, sometimes families will find out years down the road that their child has been struggling for years and years, and they didn't understand special education, they didn't know they had to ask for it, and they may have a claim against their school district if the school district also should have known but didn't trigger their child find duty. So it works both ways. When you conduct an evaluation, when the parent gives that permission to evaluate, and the school district is now doing a special education evaluation to determine if a child is eligible for that FAPE entitlement, there are a couple of things to remember. One is that it's got to be free to the family, and it's going to be non-discriminatory, and it's going to assess the child in all areas of suspected disability. It should not just be one broad test, and certainly not just an IQ test. So it's a sort of a multifaceted evaluation. While an IQ test may be helpful and may provide information and could be, informative, that's not the do-all, end-all. And again, we do want to tailor tests towards what the suspected disability is. So if you know a kid is not struggling in reading and they're doing very well, you're probably not going to want to spend your time and your money doing reading tests, right? We're going to try to get to the heart of where is the child struggling and what might be the disability that we think is the underlying problem, and focus in the assessments on that information. Parent involvement is required and is also very, very helpful in these assessments. Schools have children for a lot of the day, but Parents have them their whole life. You know, they see them all day. They know what things trigger children to do certain things. They know what their environment is at home. They know how they interact with people when they're not in school. They have a lot of input, and oftentimes can be very helpful in informing the school about, you know, what to look for and what may be helpful and what the parents' concerns are. You know, maybe you're not seeing this problem, but this is what I see. This is what the problem is. So parent input is required and very key to this process. I also want to make a note about reevaluations, and this is really, you know, you do the initial evaluation to find out if a child is eligible for special education services and going to get a program. But even after that step, once a child is in the system, or even if they're not found eligible, there's reevaluations that can kick in. You know, an initial evaluation can be requested at any time, but once a child is actually getting special education services, the law does require that they be reevaluated on a regular basis, at least every 3 years under the federal law. But Pennsylvania allows for a shorter time frame, it's every 2 years, for children who have intellectual disability. Now, the federal law still categorizes and refers to that disability in particular as mental retardation. That's why it's on the slide. I think most people and most parents and advocates who are familiar and work in the system understand that we use the term intellectual disability, but so that you wouldn't be confused or you know, the forms, until our forms catch up with our current thinking, I wanted you to be aware that it's still referred to as mental retardation on the forms and in the process. Reevaluations are not required by law to be done more than once a year. So the law doesn't sort of impose an obligation on the local education agency to do these more regularly than once a year. Again, anytime something comes up, anytime there's a change in the child's academic performance, functional development, behavioral issues, anytime, anyone can request, you know, the family can certainly request a reevaluation to figure out what's going on. The school district can propose a reevaluation if they would like to try to figure out what's going on. So these are all sort of the framework, but again, what's appropriate for any particular student is really going to depend on the student and the situation.
I just want to add that for children in the early intervention system, reevaluations have to occur every 2 years, regardless of the disability. So whether it's MR or ID, it's not just that disability that requires an evaluation, a reevaluation every 2 years. It's all disability categories.
We also have, under the federal law, in addition to those evaluations that are required to be done by the local education agency and that are required to be free to the family, families also have the right, under federal law, to ask for what's called an independent educational evaluation. This is a tool that families can use. A lot of times this will come into play if a family has requested an evaluation from the school district and the school district has done an evaluation that the family does not agree with or doesn't think perhaps was broad enough to identify any underlying or all the underlying possible disabilities. If the child's performance, for whatever reason the family feels, is not accurately reflected in the evaluation, if they think the evaluation was not given under the right circumstances or with the proper way that it had to be distributed, there are a lot of reasons why a family may not exactly be happy with the evaluation report that was done by the school district. The law allows families at any time, either because they're unhappy with the evaluation by the school district or just because they want to do it and want to get more information, they can certainly go out and get an independent educational evaluation. At any time, a family can do that if they're willing to pay for it, right? They can go out and they can get as many independent evaluations as they want by any qualified experts that they want. And then if they bring that back to the school district or the LEA, the obligation on the other side is that they must consider that information when they look at all of the data that they have on that child. The law does not require the LEA or the school district to adopt those independent evaluations or automatically accept the recommendations, the diagnoses, whatever it is. They do have to consider them. Sometimes school districts are very open to these evaluations. Sometimes they do provide really useful and additional and helpful data, and everybody's on the same page, and this is all good and it all works out well. Sometimes schools don't want to accept anything that's offered to them through an independent evaluation, and that's when we would talk about what are the procedural safeguards for families in this situation. And sometimes families really want a second opinion or a different opinion, and they just can't go out and pay for it. Evaluations are not typically what I would say are cheap. They do cost money. And so what can happen in that situation, if a family believes that the school district's evaluation is not sufficient for whatever reason that they have or whatever reasons they have, they can ask the school district to pay for, at public expense, an independent educational evaluation. The school district can then say, yes, we will do that, and here's a list of qualified evaluators that we're aware of that's in this area. Or family can bring them their candidate or who they would like, and the school can decide whether or not they're willing to do that. Or the school district can say, you know what, I think that the evaluation that we did was really awesome, and it completely covered our bases, it was really on target, it gave us enough data, and we don't think we need to pay for an independent evaluation. In that particular case, what the law says should happen next is that the school district then should automatically trigger the procedural process for the parents to go to what's called a due process hearing, which we'll talk more about when we talk about procedural safeguards. But if the school district says, no, we won't pay for an independent eval, the very next thing that should happen is that they should take the next step and schedule a hearing before an independent hearing officer who is not an employee of the school district, who's going to hear the issue as to why the family wants the independent eval, hear the district's position on why the district thinks that's not necessary, and then make a decision. And if the hearing officer agrees with the family that it is something that would, be beneficial and necessary for the child, the hearing officer can then order the LEA to pay for it. So there's a couple different routes. Again, if the family can afford it, they can go out and get an independent evaluation on their own, or multiple evaluations. They can get any expert they want with any qualifications, and they can bring it to the school district, and the school district is going to at least consider it. If they need the school to pay for it, they're going to have to ask ahead of time, and then potentially go to a hearing if it says no up front.
Going back to the independent evaluations, if you yourself pay for an independent evaluation, find your own private clinician, evaluator, submit that to the intermediate unit, they certainly, the law requires them to consider what's in it. They don't necessarily have to adopt everything in the evaluation. So, they might, again, some intermediate units are more open-minded than others. They might take a lot from the independent evaluation that you got and adopt it as part of their own. But some might reject most of it, in which case you can utilize due process hearing, which we'll talk about later. I just also want to distinguish that if you don't have your own private evaluator, and you ask the intermediate unit for an independent evaluation, if they think that their evaluation, as Sherry said before, it was awesome, they have to take you to due process under the law. That's automatic. They do not have any discretion in doing that. So just underscoring the difference between you having your own private independent evaluation and requesting a private independent evaluation from the intermediate unit.
So when we do this evaluation, this step one, and again, remember the primary goal of the evaluation is to determine eligibility, whether this student is going to be entitled to a free appropriate public education. This is really a two-step thought process when we're determining eligibility for special ed. First of all, we have to do an assessment, and at the end of that assessment, we have to be able to identify a disability that the law says is going to get you to special education services. It's got to be on the list of identified disabilities under the law that says if you have this disability, you have met the eligibility criteria, at least as far as diagnosis, for getting an entitlement to FAPE. The law tells us what those disabilities are. So this step one, child must have a disability, and then you'll see the list of bulleted points underneath of it. These are the identified category of disability that will get you over the first hurdle. So does this child have a disability? Some of them, again, are self-explanatory. And again, we use the term mental retardation because that's what the law still uses. But as we know, this would be children with intellectual disability. Kids in the age range from 3 to the age of first grade, when they start first grade, can also be identified as having a developmental delay. That would be enough to get them in the eligibility criteria. Hearing impairment, speech or language, visual, those things seem to be somewhat self-explanatory. Emotional disturbance, I always find, is a little bit trickier. If you actually look at the definition of emotional, it's kids who have an emotional disturbance, but who are not socially maladjusted. So figure out what that means. But you want to be sure that if you're trying to get a special education program for a child and that they get this entitlement, you want to make sure that the assessment reflects an emotional disturbance and is clear about that. So that one's a little bit more tricky. Other health impairment is another one. You think to yourself, what's another health impairment? Has anybody ever got a diagnosis outside the school district that says other health impairment? I don't know. I know lots of kids get diagnoses of ADD or ADHD or oppositional defiant disorder. There's a lot of things, a lot of different labels that we put on kids. Sometimes they have asthma or sickle cell anemia. What are these other things out there, and can we fit them into one of these definitions? And I will tell you that other health impairment is a very broad definition. So if you get a diagnosis for a child that's not one of these bulleted points, read the definition for other health impairment because it may fit underneath that category.
And I just wanted to make a point about intellectual disability. Earlier, Sherry talked about the need to have an evaluation every 3 years. If your child is identified as having an intellectual disability, there's actually a rule that they can be and need to be evaluated every 2 years. So if you suspect that the child may have an intellectual disability, but it hasn't been identified, and maybe they've been identified as something else, like in the other health impairment category, I've had this kind of case before, it may be good to ask the school to do some testing to look to see if they do have an intellectual disability.
Specific learning disability is another trickier one. There's a few extra additional things that have to be found out when a child is identified as a student with a learning disability, so that's another one to pay attention. Once you have the assessment and you have figured out that you have a child who has an assessment that is leaning towards one of these identified categories and will support the identification of the child having one of those identified disabilities. The second question is then, as a result of that disability, does the child require special education and related services? So you have the diagnosis. The next question is, because of that disability, does the child need special education and related services? And on this slide, you will see the definition of those two things. Special education is specially designed instruction, which is adapting the content, methodology, or delivery of instruction to address the unique needs and ensure access to general curriculum for that child, so that the child can meet educational standards that apply to all students. Related services are things like transportation and such developmental, corrective, and other support services that are needed to help the child benefit from that special education that's referenced in the first bullet. So that sometimes can be a little bit of a tricky question too. You may have a child who has an assessment, who gets a diagnosis, but they really don't need special education. And this is where those other laws we talked about at the very beginning when we did the overview may come into play. So a child who doesn't necessarily need a special education plan, because they're doing pretty well academically, developmentally, functionally, they may still need some accommodation or some help at school to make sure they have equal access and can benefit from the same programs as their fellow students, right? So, the most simplistic, and this is just a very basic example, you could have a student who has a mobility impairment, who does not need a special education program, is not struggling at all in any of those areas we talked about, but in order to benefit and have access to the building, they need to get a ramp put in, or if there's an elevator in the building, may need to have access to the faculty elevator to get up to the second floor, or may need access to a faculty bathroom because that's the most accessible bathroom. So these situations can exist where maybe the student doesn't need a special education program or any of those related services, but they might need an accommodation or some other support that would not be in the definition of special education and related services that they could very well be entitled to under the Rehabilitation Act, Chapter 15 in Pennsylvania, or the Americans with Disabilities Act. So we want to keep in mind that just because somebody's they're not qualifying, they haven't met those two prongs we just talked about for special education, they might still have, a disability that substantially impairs a major life activity, and learning also can be one of those. And again, they would be protected by, at a minimum, Section 504 and Chapter 15 in the ADA. Now again, we're focusing in on the kids today that are going to require special education, but we don't want you to forget, if you're helping to advocate for a student that maybe doesn't fit into the eligibility for FAPE and for special education, you may still have a way to help advocate for that student with these other laws in mind.
And I would just add that this is really an area to sort of watch out and be mindful of it, because I have seen situations where, for example, if a student needs specialized transportation, maybe the school district suggests, oh, we can just do a 504 plan, that's really all they need. They don't really need an IEP because they don't need anything else. All the while, the school district is maybe overlooking the fact that the reason why the student needs specialized transportation is because they're having behavioral issues on the bus, and maybe these behavioral issues are really a sign of something else, and maybe some social skills training or other special services in the classroom could really be helpful. So, this is sort of a murky area, and you kind of have to be mindful if it's being suggested that the student maybe only needs a 504.
But we've worked our way through the evaluation process and the identification process, and now we are at the step where we have a child who's been evaluated, who has one of those identified disabilities, has met the criteria for being eligible for FAPE, and now we need to write a program for that child to make sure that they get that FAPE, right? They get a free appropriate public education, but we need to know what that looks like. So we're going to write something called an Individualized education program. This is, by definition, a team process with mandated team members. So this is not a situation where a local education agency says, okay, your child needs services and here's what you get. Here's the program that we give to kids who have this disability. This is what we do here in this district. That's not what it is. It's supposed to be a team process where there are mandated people that have to be at the team, including somebody who's typically the certified school psychologist who understands the evaluation that's been done and what the identified strengths and needs are as part of that should be at the table. Anyone else from the district, like teachers, regular education teachers, if the student is in regular classes, special education teacher or teachers if the student is pulled out for any reason, parents, obviously part of the team.
Just to add, the IEP team for children in early intervention, again, ages 3 to 5, typically involve a lot of therapists because, there tend to be more unrelated services for early intervention children. So, for example, a speech therapist, the occupational therapist, other therapists, other specialists that might be familiar with the child, maybe medical professionals. And it's very important for the IEP team to include either a service coordinator or other representative from the intermediate unit or LN who are familiar with programs on providers that the intermediate unit has to deliver services so that the parent knows what options are available. And of course, as Sherry said, the parent is mandated to be part of the team, and it's important that they be involved.
So because it's a team process, you have the meeting, which we know is called the IEP meeting, where the parents and the LEA can agree in writing that certain team members need to not be in attendance. And this is really a flexibility thing, I think, for families. There are mandated people by law who have to be part of the IEP meeting. But how often do you have a situation where not everybody can get together on the same day? It has just become a logistic nightmare to schedule an IEP meeting to make sure that everybody on the team is always there at every meeting. It can be very difficult. And so to give schools and families some flexibilities to get things done without this sort of other requirement, both the parents and the district can agree in writing if they think that certain team members don't really have to be at the meeting because we're not really going to focus in on whatever service or program that particular individual has an expertise on. Even if they are going to talk about some of that stuff, reports can be submitted in advance of an IEP meeting where changes are to be made in areas where team members are not going to be there. So again, I think the goal here under the law was really to give parents and LEAs some flexibilities to make sure that they're giving student services without actually having to worry about finding a time that everybody can get together to do that. But you get this group of people whose mission is now to look at this assessment, look at the strengths and needs, and write a program that is going to make sure that this child, while they're in school, gets to make meaningful educational progress. Again, based on that particular student. So we're going to write in this IEP what is called measurable annual goals. And again, these can be academic, but they can also be functional. You know, if this child has behavioral issues, we're going to want to see some behavioral goals. And if they need to learn different types of life skills, we want to see goals in there that are going to help them to get meaningful education from their program, not just the academics, but certainly the academics will be part of it. We want to see specially designed instruction in that document. In academics, physical education, travel training, vocational education, again, whatever's appropriate for that student, which is going to depend on their strengths and needs, it's going to depend on their age, it's going to depend on what their goals and dreams are for after they get out of high school. All of these factors are going to come into play. We want to see in there any related services that are necessary, including things like transportation, speech therapy, physical therapy, counseling, whatever it is. Again, that ensures that the child is going to make meaningful educational progress in school.
Okay, so now we're going to talk about the transition to kindergarten or first grade process. Again, just to remind you, in early intervention, children can stay till through age 5, and you can, assuming a school district has kindergarten, enroll your child in kindergarten. But in Pennsylvania, kindergarten is optional, so you might be transitioning your child to first grade. Either way, the spring before the first year of kindergarten or first grade, there should be an IEP meeting with the intermediate unit or Elwyn and a representative from the school district to talk about things like enrollment, as far as what school in the district is the child going to attend, what services the school district has, writing goals in the IEP so that the child can start working on things before they get to kindergarten, so it's a seamless transition. Maybe the school district wants to talk about setting up their own evaluation, a school age evaluation process. So these are just some things that would come up at this transition IEP meeting, again, the spring before kindergarten or first grade.
Assistive technology is part of this conversation. Do we need devices or services to increase functional capabilities of the child? Assistive technology is part of the deal. It's part of FAPE. So it's definitely on the table and can be considered to be something very, very simplistic, or it can be something very complicated. But all of this should be looked at. The thing about an assistive technology device, the only caveat to that would be, again, we were talking about education services that are provided for education benefit. And so once the student is no longer in school or graduates or moves on from school, it's not their device or their system. They don't get it, doesn't belong to them. It's provided through the school, so they might not get it forever or take it with them once they age out. Sometimes things are offered in school so that they can access the school program that they may not need at home. Sometimes things don't leave the school building. But those are all things that can be discussed by the team. Overall, if a student needs assistive technology and they also need it once they go home at night for homework or for whatever reason, they're going to get it there too. And special factors. So kids who have behavioral problems in school, kids who have limited English proficiency, children who have visual impairments or communication needs, there are sections of the IEP that are specifically focused on how do we address those particular needs and what services are we going to give them to make sure that, again, at the end of the day, they're making meaningful educational progress on these goals and objectives. Now, ideally, every kid should be doing the general education curriculum that's grade appropriate and age appropriate. So we always want to start there. What other activities and extracurriculars and all that other stuff are their same age peers doing? All of that should be available and on the table for children with disabilities. Can we provide them with supports and services to do it? What do they want to do? What are their goals? Again, this is all very meaningful and individualized program that's put together by a team. So the school district doesn't, at the end of the meeting, doesn't get to trump the conversation and say, great conversation, here's what we're going to offer, because this is what we do here, right? And so you have to be, red flags go up when there are already certain programs and certain things that the district has in place, which again, I'm not faulting districts for having services and programs set up, because administratively that's a good thing, and it can be beneficial, but you don't have to fit a kid into an existing program. So remember, if the program is appropriate, wonderful. If it's not appropriate, you can look beyond what we do here. right? It's all about the child. On the next slide, you will see another slide about IEP Team Meeting. And again, with regard to just being more flexible, the law also allows for alternative means of meeting participation. So teams can meet by conference calls and video conferencing. If that's an option, they don't all have to be sitting physically in the same room. They can make amendments to the IEP without a meeting if the district and the LEA have agreement to do that. So you can even circumvent the meeting itself under certain circumstances. And changes can be made to the IEP through written amendments rather than rewriting the full document. So you don't have to sit down and go through every section of the IEP if you know you only want to talk about one section that needs to be tweaked on reason. All about flexibility and making this somewhat complex system work more practically in a world where not everybody can get together and be available all the time. And depending on a child, a meeting could go pretty long. If you need to make a lot of changes, or you need to deal with a lot of issues, or you need to really take in some new assessment data and figure out how to change things. So finding a 3-hour block of time for everybody at the same time can somewhat be impossible at times. So this is all about flexibility of meeting.
Can you talk about taping an IEP meeting?
Okay.
Like who's responsible? What rights do each side have?
Yeah. So the question is taping an IEP meeting, and I'm assuming you mean can the parent bring a tape recorder?
Mm-hmm.
And this issue has come up somewhat frequently. I wouldn't say frequently, but I've heard this for a long time. And you're going to have to help me on this, Jamie, because I haven't looked at it for a long time. My memory is you do want to tell the district that you are taping the meeting. Do not sneak in a tape recorder and click play, right? Because there are wiretapping laws that will apply to you if you do that. So you have to tell them, I want to tape this meeting. Now help me with what the district's response can be in those situations.
Well, as far as I'm aware, the district can say that they do not want to have the meeting taped. But in some instances, the parent may be asking, and I've had this, to tape the meeting as a reasonable accommodation, because sometimes we have situations where not only does the child have a disability, but the parent also has a disability. So if that's the case, then again, the parent needs to say that up front and, make sure that their request is put in place before the meeting actually happens.
So it's not an absolute, I would say, is probably the right answer to that question. Definitely notify the district that you're bringing a recording device or you want to. No secret recordings, that's an absolute. But if the district says no, you want to focus in on what is the reason that the parent wants to take the meeting. Is it because that is the only way that they can have reasonable participation in the meeting? If they have a disability where they're in the room, and maybe they can't take in all the information for whatever reason, they can't write it down, they can't listen to it, they need to, after the meeting, listen to it again so that they make sure they got it, they understand. That's one situation. If you have a parent that says, I'm coming with a tape recorder because I'm going to get everything that, this teacher says about my kid because they're terrible and they say all these bad things, you're probably not going to get very far. So having a good reason to bring it, that's more related to just so the parent feels like they're getting all the information accurately and they can process it better is probably a better way to ask for it so that it looks more like an accommodation than whenever you say something bad, I gotcha, like you're on tape, then you're probably going to get denied.
So the district has to say yes to a reasonable accommodation for the parent.
Yeah, if the district says absolutely not and it becomes a reasonable accommodation issue, that's a different resolution than this system that we're talking about. Because then you're talking about parent rights as opposed to FAPE entitlements for kids.
Right.
Yeah.
Okay.
The final step, I would say, in this process, on the substantive side of the equation, is figuring out the placement for the child. Once you have a program written in the IEP, and again, the last question should be, okay, here's all the services and supports that the child's going to need to make meaningful educational progress. Where are we going to implement this program? And that is the placement decision. And again, it really should be done after you write the IEP. I hate it when I hear calls from parents that say, I got an evaluation, so we're still in step one. My child has this disability, and the very first thing the district said is, great, we're going to put them in this classroom in this building over here. Because that's a placement decision, right? And this does come up, I think, probably most often in my personal experience when a child gets a diagnosis of intellectual disability and the district automatically wants to put them into a life skills program. Again, I'm not saying that districts can't have a lifeless program. They are supposed to legally have a continuum of placement options for kids. What I'm saying is diagnosis should not drive placement. Diagnosis is just the first step. Watch a red flag is when kids are put into placement programs because of their diagnosis. That's not a good thing. You make a placement decision based on the assessment and what the identified needs and strengths are, what services and supports are going to be in place, and then where can that be implemented that is the least restrictive for the child. And we want to take into consideration the law requires the least restrictive environment. This is not just a guideline, this is a mandate. And you also have to consider what supplementary aids and services can be put into that least restrictive program to benefit the child. So I always tell people to start off with the premise that every single student, regardless of disability, can educate in whatever classroom and whatever school they would be in if they didn't have a disability, and work backwards from there. So make no placement assumptions based on diagnosis or what you think the child's going to need. Start off with the concept. They should have the right to go to school, the same building and the same classrooms as everyone else in their neighborhood who's going to that school. Can we do that? Because that is what everybody should get, and that's what the entitlement is. Then, once you start to look more closely at what kind of supports and services are needed, and when that becomes to look like maybe we can't do that fully in classrooms for 100% of the day, you can start talking about other options. But you should start with the premise that everybody's included, and then we work backwards from there. And that is really what the least restrictive environment mandate requires for the IEP team to do. This is, I think, a point again where I'll say, during the conversation about placement, it may come up that the district and sometimes the family will agree that the child really cannot be meaningfully educated in a typical classroom, maybe not even in the public school building or even within the district, and they want to look at other programs or placements that are out of the district. If the family and the district agree to that, you could have a situation where you have a student who's enrolled in their public school district but is fully educated in a private school or some other program that's not operated through the district. That's okay. They still get an entitlement to FAPE, they still get all the procedural protections in that environment, but that's because the IEP team made that decision and there wasn't consensus as to that. So you make the placement decision, and again, since this is the last step of the process now, this would be the point in which the district would give that notice to the family, right, the NORA, the Notice of Recommended Educational Placement that says, we talked about a lot of things, we talked about sports, we talked about services, we talked about placement, this is what we're offering, this is what we think is FAPE for your child. Parent gets that written document, and pretty much the rule is if they agree with it, or if they silently disagree with it but do nothing, all of this is going to go forward, usually within 10 days at the outset. If the parent agrees, great, everybody's on the same page and things are going to go full steam ahead. If the parent doesn't agree but doesn't say that or doesn't make that clear to the district and the district is not on notice of that, they're going to go ahead and they're going to go forward with what they've proposed because silence is going to be construed as acceptance, right? So if you are a family or parents, you're advocating for your child or someone else's child and you realize quickly that you really don't agree with any of those things, right? One or more. Placement decision, programming decision, services, how the goals were written, whatever it is. You want to decide sooner rather than later that you don't agree, and you want to make that clear, and you can make that clear on that NORA. You can check off that you disagree. I personally tell people they can write on that NORA too. Like, you're not really confined to that little checkbox. You can write whatever you want on it as far as I'm concerned. It would still be evidence in a due process hearing. So you want to put on there what you disagree with, and then you have to decide what you want to do about it. So you have to make a decision. If you don't agree, are you then going to trigger one of your procedural options to try to resolve that dispute? Because I can tell you, even if you disagree, and even if you check the box that says I don't agree, and even if you write on there why you disagree, if you then don't decide to exercise one of your procedural rights, there's a good chance that it's going to go forward anyway, because the ball is going to be in the parent's court to do something about it.
I just want to underscore some differences in the discussion of placement and the NORAP for children at early intervention, ages 3 to 5. Sherry just talked about placement in the LRE with supplementary aids and services, which is absolutely mandatory, but she talked about different classes, which doesn't really apply to children at early intervention. In EI, we talk about the LRE being a particular preschool so that children can be alongside non-disabled peers. Some options that intermediate units and LN use are, sometimes they have a reverse mainstream program, which it's called, where they run their own preschool with children who have and do not have disabilities. That would potentially meet the LRE. Sometimes there are Head Start classrooms in school district buildings which any child can attend regardless of their disability. That could also meet the LRE, but certainly intermediate units also have to have a continuum of placements. So some of them offer center-based programs where there are more children with disabilities or smaller classrooms that have maybe specialists in the classroom. Sometimes services are delivered at home if the child is not able to attend an actual school, but that is on the more restrictive end. And sometimes it can be a private preschool if there aren't any options available, such as Head Start. So those are some of the placement locations for students in EI. Also want to talk a little bit about the NORAP. One difference in the NORAP for EI is that a parent has 14 days to either agree or disagree with the IEP, the placement that was presented to them. As Sherry said, they should certainly check the box and include any other information as to why they disagree. But if they don't mark anything down or do not take steps to institute any dispute resolution mechanisms, in 14 days that NORAP will be adopted by the intermediate unit or L1. So that's placement and the NORAP for early intervention.
So that's going to lead us into our next part of the discussion, which is the procedural stuff. Obviously, relationships between the family and the players in their school and their school district are really important, right? Because these kids are at these schools for years and years and years. You really want to have good relationships if and when possible. So to the extent that you can resolve any disagreements informally, we always say that's the best approach, right? If you can even just talk to a teacher and say, look, I'm really uncomfortable with, we talked about this at the meeting and I don't really feel comfortable, here's why. Teacher may be able to help you get to the resolution you need. You can talk to the principal might be able to help you get there, right? IEPs can be amended at any point, right? They're not set in stone for a year. They have to be looked at least annually, but they are flexible documents that can be changed at any time. So just because you sat in the meeting on Monday and didn't express your disagreement doesn't mean that you can't do it Friday and get a change made to that document. So informal resolution is, obviously it's the fastest way, and it may be a really good way if there are good relationships between the family and the district. There's also this thing called IEP facilitation, which is offered through the Office for Dispute Resolution, where if what you think you need, you don't really know how to get there as a parent, and you think maybe having a facilitator at the meeting could be beneficial to you, they will offer to send an IEP facilitator to your IEP meeting. So it's not necessarily a bad thing. It could work wonders in a situation, just even to help everybody get on the same page. And sometimes people just don't understand what the conflict is. Everybody thinks they're in agreement, and then they're shocked when they find out that they're not. So sometimes a facilitator can be very helpful. It does have to be agreed to by the district and the family, so if one side is not in agreement, it can't go forward. But that is one informal way to resolve. If you can't do it informally, there are options to do it more formally. One of which is you can file a complaint with the Division of Compliance, which is within the Pennsylvania Department of Education. Now, my personal belief is that this is an effective tool, not so much when you're having a fight about what's an appropriate program, service, or placement. So if there's like a difference of opinion about what's appropriate or what's necessary, I don't think the DOC is going to help you that much. But if you have a problem with implementation, like you have an IEP that you like, but for whatever reason you feel the district is not implementing it. And sometimes those are really obvious, clear-cut cases, and sometimes maybe not so much. But if you feel like you have an implementation problem, DOC may be able to help you, because the Division of Compliance will hear the parent's complaint, do an investigation, talk to the district, and then make a decision about whether or not the district actually did what they were supposed to do. So sometimes that can be helpful on implementation. It also can be helpful on timeline issues. Like, for example, if the parent has given consent to evaluate, the district has agreed to evaluate, and now you're way beyond 60 days, and still nothing has happened. If you file a complaint with the Division of Compliance, what should happen is they will investigate, determine the district is out of compliance, and make them finish that process sooner rather than later. So an effective tool in those sorts of situations. If you're having a fight about what's appropriate, more of like what is FAPE for a child, whether that's programming or placement, probably not so much the Division of Compliance. I think they've said over and over again they don't resolve issues of appropriateness, even though I disagree that they can do that, they do it anyway. They say it all the time. So mediation could be an option. That is also through the Office for Dispute Resolution. They will appoint a trained mediator to come meet with both the family side and the school district side. There are no lawyers allowed at mediation, so that makes everybody much more on an even playing field in those types of situations. And to the extent that the mediator can get the sides to actually mediate and get to a common ground, the family will get a binding agreement out of that meeting. So they will walk away with a legally enforceable agreement, and everybody is theoretically happy. I think the statistics reported for how many people are satisfied mediation services is pretty high. At least last time I looked, they were reporting a pretty high percentage of happy customers, so it'd be another way to do it. If you feel like there's some middle ground or some flexibility on either side. The next slide is more for, if mediation doesn't work or you don't want to go there, or one of the parties doesn't agree to mediation, which makes it a no-go, you may end up in a much more formal resolution, which is called a due process hearing. Now, the Office for Dispute Resolution has this thing they set up called evaluative conciliation conference, where they actually have a consultant at the Office for Dispute Resolution who will say, all right, you're headed towards a hearing. I'm going to meet with the parent. Tell me your case. Tell me what evidence you're going to present or you think you're going to present at the hearing. Then this person will meet with the district and say, all right, what's your side of the story? What's your evidence? What are you going to argue at the hearing? And this person, this evaluative consultant, neutral consultant, will make a judgment about what your chances are at winning in a due process hearing. And sometimes hearing that from somebody who's neutral, was not invested in who wins, doesn't care, just wants to hear the evidence and has experience. Rosemary Mullally, I think, is the person who does it, and she's been a hearing officer before, I believe, or at least she's litigated on behalf of school districts in due process hearing, so she's been to quite a few of them. She will give you just some sort of understanding of what your chances are. And sometimes hearing that may push the side who's not on the winning end of that equation to settle, or to come to an agreement where maybe they weren't willing to do that before. They don't want to go through the time and expense of the hearing and the emotional stress of it if they think they're going to lose anyway. So sometimes that can be helpful. Again, it's optional. Parties don't have to engage. Due process hearing is the most formal resolution. You actually go to a hearing. You have a hearing officer that sits as the judge. Whoever requests the hearing, which I think in most cases is typically the family, has to put it in writing, their complaint notice, and they have to make sure that the other side gets it, so that the district or the LEA gets it, knows what's coming. A hearing officer is appointed. You have a hearing session. At this session, you have what's called a burden of proof. So the person who has requested the hearing and who has filed the complaint has a harder job to convince the hearing officer that their case is valid. Because how it works is if the case is pretty even, if the hearing officer feels that, okay, well, the parent has a good case, but the district makes a pretty good case too about why they are where they are. If it's about equal, the person who has, or the party who has the burden of proof is going to lose. So they have to be 51% as opposed to the other side, right? They got to be that much more convincing. Whoever requests the hearing has the burden of proof. I will tell you practically that's most of the time the family. You can have a lawyer at the hearing, but you don't get one. The family doesn't get a free lawyer. So if they want to go and they want to bring a lawyer, that's fine. They will not get a lawyer appointed to them at a special location due process hearing. If, however, they prevail at the hearing, the law allows the family to seek reimbursement for any attorney's fees from the school district. So if they pay for an attorney, they go to a hearing, they prevail, they can then seek reimbursement of their attorney's fees from the school district. What they cannot recover is expert fees. So if they had to have an expert come to the hearing to testify, present evidence, and that person charged the money to be there, they will not be able to recover expert fees from the district, even if they win in that case. And of course, anybody, each side at the end of the hearing has a right to appeal. There used to be another administrative appeal level in Pennsylvania where you would go before you would actually get into court. That's been gone for a long time, so if a family or a district doesn't like the due process hearing decision and wants to appeal, you're talking about going into either state or federal court. And I would advise, if I had a client that was a parent, if you're going to appeal, you're going to want to probably go into federal court. That's a much more, I think, familiar and friendlier forum who understands. It's a federal law primarily that we're dealing with. Federal court is probably the better forum, I think, in most cases that I've ever seen.
I absolutely agree. And I would say that while it may be okay to sometimes go to a due process hearing without a lawyer, don't spend your time and your money going to federal court without a lawyer.
That's right. I should say parents don't have to have a lawyer to go to due process. They certainly can represent themselves and their children without a lawyer. The only bad side to that is I've never seen a district show up hearing without it. So the parent is going to be the unrepresented party at the hearing if they decide to go along. That said, I think quite a few parents have prevailed at due process hearings without a lawyer. So it really depends on the situation. It depends on the case. It depends on how strong the case is, what the evidence is, how easy or not easy to be convinced the judge.
So I just wanted to talk a little bit about some common issues and areas in early intervention services that come up that parents sometimes deal with, that we see pretty often here. The first deals with the transition to kindergarten. Sometimes districts just do not meet with intermediate units and the parent for an IEP meeting in the spring before kindergarten or first grade, and this can be problematic because it means that there could be delays in, for example, the school district doing a school age evaluation, before the child starts kindergarten or first grade. Could be delays in enrolling the child in the school age program, putting goals together for them in the IEP so that they can start working on things in their last year of early intervention. So to resolve this would be under the informal being aware that this meeting takes place and to remind the IU that this meeting has to happen, perhaps bringing in IEP facilitation to deal with this meeting. Those are some ways to handle this problem, but sometimes parents are not aware that this meeting actually has to take place, so important to remember that. Circling back, in early intervention, something we see a lot is delays in delivering services agreed to in the IEP. For example, a child might be supposed to receive 2 hours of speech therapy per week in an IEP, but for whatever reason, the service is not delivered, and several weeks go by, student has missed 8 hours, 10 hours, however many hours of speech. So to deal with this problem, certainly you can first try the informal mechanism of asking the IU, mentioning, hey, you haven't delivered on this therapy. Can you make it up? That's 10 hours my child didn't get of speech. If they don't, you can file a Division of Compliance complaint, as was discussed previously, and then the state will do an investigation, and if in fact the services were not provided, they will force the IU or Elwin to make up those services or provide compensatory education. And finally, I just want to talk about another issue we see quite often is intermediate units or Elwin refusing to pay for a private licensed preschool if they do not have reverse mainstreaming or other inclusive options. Frequently, parents are denied reimbursement for a private preschool even if their child needs specialized instruction. Again, the IDEA requires that FAPE be delivered in the LRE, so an intermediate unit has to have options to deliver on that LRE. So IUs do not often want to pay for a private preschool, so if that happens, again, you can certainly bring it to their attention. You can ask them for reimbursement or to find another option that meets the LRE. If they refuse, you can certainly attempt beginning with the formal mechanisms for dispute resolution, mediation, but frequently we see that parents have to resort to due process. So you would file a complaint, and you certainly can call us for advice on that, because very often it's helpful for parents to have a legal counsel and a due process complaint. So these are just some of the common issues and areas we see with early intervention. Problems with the transition to kindergarten, the private preschool LRE issue, and delays in delivering related services already agreed upon in an IEP. All right, so this last slide gives information about our intake line and email. Disability Rights Pennsylvania. We do protect and advocate for Pennsylvanians with disabilities, birth through death, for special education, as well as anything else disability related. So if you have a question or concern, you can give us a call at 800-692-7443, extension 400. You can also go to our website at www.disabilityrightspa.org, and you can submit an intake through email as well. That's intake@disabilityrightspa.org. We have offices in Harrisburg, Pittsburgh, and Philadelphia. No matter where you live, someone will be able to address your legal concern. It might not be the person who works closest to you, but your call will be routed to the person with the most expertise in the area you're calling about.